Hello everyone, this is Crypto BitLaw back with another video, and today we're going to discuss how a recent order from a federal judge permits the plaintiff in the Hex class action lawsuit wherein they're suing CoinMarketCap and its parent company Binance US, and its CEO and founder Changpeng Zhao, affectionately known as CZ. The judge is allowing in that case CZ to be served via Twitter, because the plaintiff has been trying to serve him for months now and has been unable to, because CZ hops from jurisdiction to jurisdiction, different country to different country, essentially avoiding any sort of centralized jurisdiction, and they refer to him in the pleadings as an international ghost. So we're going to be covering this. Apologies if the sound is a little off. I'm recording this in my car while I'm waiting to pick up my kid on my laptop, so I don't really have my full-on setup, but we're going to get through it nonetheless and break everything down. But before we do, if you like this content, please hit the like button and subscribe to our channel. We'd really appreciate that. So with that said, let's jump on in. Okay, so I think this is a good place to start off with. Here we could see the plaintiff's lawyers, the Davalier Law Group. They, on November 12th of 2021, tried to file service they tried to effectuate service against CZ via Twitter here in this post on November 12th, and here is a copy of the summons and the civil action, and they sent a Dropbox link with the actual complaint, and we could see here it was directed to defendant Changpeng Zhao, or CZ. And then my man Johnny Chaos did a shout out today where there was an update in the case that perked our interest, and so we hopped on the docket, and let's show you what we found. So here's a copy of the docket in this case. The caption, the title is Cox versus CoinMarketCap et alia. And yeah, as we could see before, it's in the District of Arizona. And there's been a fair amount of movement. Most of this was just notices of counsel appearing and getting motions to appear pro hoc vice, so on and so forth. But down here, it started getting into the juicy nitty-gritty of around when the plaintiff was unable to serve CZ via traditional means, where you actually go and have a process server or a sheriff, depending on what jurisdiction you're in, physically give a copy of the complaint to the defendant, and that would effectuate service. And the plaintiff wasn't able to do that because CZ, I'm sure as most of us know, just kind of hops around from country to country, jurisdiction, like this amorphous ghost, and they even refer to him in this judge's order as an international ghost, which is interesting because I think the judge finally caught on to what the heck was actually going on here. And so recently, despite all this, there was these updates where, I guess in pertinent part, there was an order granting the plaintiff's motion for extension of time for service and alternative service. As outlined above, it's further ordered that extending the time to serve Defendants Zhao, Lin, Hay, and Coley by 60 days. And so earlier, he filed a motion for alternative service. It was somewhere up here. I don't know exactly where it is, but trust me, it's in there. We went over that in a previous video. So let's dig down into this order, and we'll see what sort of relief the plaintiff was granted on March 1st by the judge. So, all right, so here we have a copy of the March 1st order, and we're going to go through it line by line because it's not very long. It's only 6 pages letter-sized. So let's go down, let's see what it's all about, and then we'll break this down at the end. All right, so we can see the caption up here, the case number, and then the little introduction and background. So on line 15, it begins, pending before this court is plaintiff's second motion for extension of time for service for alternative service by email, social media, publication, and or other methods, known as the motion. And then this was a document entered as document 50 in the docket, okay? So continuing on, it states, the court heard oral argument on the motion on February 25th, 2022. The court has reviewed the motion and applicable law and now issues this ruling granting the motion. Okay, win for the plaintiff. And here's the background. Plaintiff Ryan Cox filed a complaint with this court against CoinMarketCap LLC, CoinMarketCap.com, Binance Capital Management Company Limited, Binance, BAM Trading Services Incorporated, doing business as Binance US, as well as individuals Changpeng Zhao, Catherine Coley, Yi Hei, Ted Lin, and Does 1 through 10 for artificially suppressing the value of the cryptocurrency HEX and artificially inflating the value of other cryptocurrencies. Plaintiff notes that Binance has been described as an international cryptocurrency exchange that hops around from jurisdiction to jurisdiction to avoid regulators. And then there's a cite to a document. And I think that's most likely either one of his motions or his, probably his motion because his complaint would be earlier on in the document number. Okay, continuing on. Here, plaintiff has successfully served process on the corporate entities in this lawsuit, but has failed to serve each of the individual defendants, who, plaintiff notes, are Chinese nationals whose country of domicile cannot be ascertained. Defendant Zhao, id at 2. Well, just for those that are uninitiated, id, whenever you see id in a legal pleading, all that means is to look back to the most recently used cite. So id would mean that they're citing to this, document 24, at page 2, right? So I guess technically this person didn't need to put at 2. They could have just put id because document 24 in this previous site right here already referenced page 2. But that's just nitty gritty appellate lawyer stuff that I was well versed in. That's my level of attention to detail. But continuing on, Defendant Zhao, the CEO of Binance, has been on the record stating, quote, Binance.com has always operated in a decentralized manner as we reach out to our users across more than 180 nations worldwide, as well as pushing the envelope and experimenting on how to become a true DAO, or decentralized autonomous organization. And there's the id site. Plaintiff has taken extensive action to locate the whereabouts of the individual defendants, who are officers of Binance. All of plaintiff's efforts have been fruitless. Plaintiff describes these individual defendants as, quote, international ghosts. A private investigator hired by plaintiff could not even identify the country of residency for a single Binance officer. Color me shocked. The private investigator was, however, able to identify the Twitter accounts associated with defendants Zhao, Ted Lin, and Yi He. On November 12, 2021, undersigned counsel tweeted a copy of the summons and a link to the complaint in this case to all 3 Twitter accounts. Twitter has verified each individual account, and plaintiff notes that each user utilizes their account on a regular basis. On December 13th, 2021, the court entered an order denying plaintiff's motion for alternative service, asking the court for permission to serve the individual defendants in the case via social media. On February 1st, 2022, the court denied Defendant Coley's motion to dismiss for lack of service, finding that an extension of the time to serve Defendant Coley was warranted, given the difficulties in locating the individual defendants in this case. Wow. This defendant right here, Catherine Coley, pretty much tried to avoid this lawsuit by hiding out. This is me talking right now. Hiding out and living under a rock and trying to avoid being served, and then comes along after the fact and asks the court to dismiss it for lack of jurisdiction for not being properly served. And thank God there's some sort of competency in these courts where the judge saw right through that tactic. It's like, no you don't. Nope, not happening. They get an extension. Plaintiff, you get an extension. Let's serve her. So that's music to my ears. It gives me faith in the justice system. All right, continuing on. Plaintiff once again moves this court for an extension of time to serve the individual defendants in this case and to serve the individual defendants in this case via alternative means, including by email, social media, and publication. Since plaintiff's last motion to serve by alternative means, he has taken additional steps to locate and serve the individual defendants. Despite plaintiff's continued efforts to locate defendants Changpeng Zhao, Ted Lin, and Yi He by hiring additional investigator and by following the Twitter accounts of all 3, plaintiff was, again, unsuccessful in locating, ugh, I hate that grammar, in locating the whereabouts of all 3. Additionally, this is a judge. This is actually, it's the judge's clerk, but I mean, come on. Additionally, plaintiff attempted to serve Defendant Coley at addresses in Puerto Rico, Florida, and North Carolina. All efforts have been unsuccessful. All right, part 2, the discussion. This is where we get into the bulk of the law as applied to the facts that we just went through, right? Okay, so subsection A. Good cause exists for an extension. This is where she's going to tell the parties, hey, there's a good reason for the plaintiff to get an extension to serve because clearly these defendants are ducking service, which is plain as day. All right, so it begins, a court must extend the time for service if this is the statement of law, all right? A court must extend the time for service if the plaintiff shows good cause for the failure to serve. And then this is the law that it cites, the Federal Rules of Civil Procedure, Section 4M, Rule 4M. Rule 4M requires a district court to grant an extension of time when the plaintiff shows good cause for the delay. And here's some jurisprudence that's precedent for that case. EFAW versus Williams. And then it's in the volume 473 of the third federal volume, and then the page site, the pen site to it. And this came out of the Ninth Circuit in 2007. That's how we read citations. All right, continuing on. The court will grant plaintiff with an extension of time in which to serve the individual defendants in this case. Plaintiff has shown good cause for its delay in failing to serve Defendant Coley. Plaintiff attempted to serve Defendant Coley at 3 addresses associated her. Oh my God, who wrote this? Let's read this again and see if this is good. Plaintiff attempted to serve Defendant Coley at 3 addresses associated her and were unsuccessful. Okay. Additionally, despite speaking with Defendant Coley's mother in North Carolina, got in touch with her mom, plaintiff was unable to get an address for Defendant Coley, whose mother described her as a nomad. Oh my Lord. Further, plaintiff has made extensive efforts to locate and serve defendants Changpeng Zhao, Ted Lin, and Yi He, all of which have been unsuccessful. Accordingly, because plaintiff has shown good cause for the delay, the court will extend the time to serve the individual defendants by 60 days. All right, so breakdown of this. The reason the court gave the plaintiff more time to serve is that, okay, let's apply the law to the fact. The law requires a district court to grant an extension of time for service if the plaintiff shows good cause for the delay. Plaintiff showed good cause. One of the defendants is a nomad. The others are ducking service, and the plaintiff has made bona fide actual multiple attempts. Tried to serve this Coley lady in 3 different states. Tried to serve the Chinese ones in 3 different countries. That's good cause. And I think it's due in large part because of the plaintiff's diligence in trying to serve these people despite their efforts to duck service. That's why the court actually saw that there was good cause, applied the law that requires an extension to be granted if good cause is shown, and said, hey, based on the facts, you comply with the law, you're going to get your extension. All right? That's the analysis there. All right, Section B, alternate service. Rule 4F provides 3 methods of serving an individual in a foreign country. First, by any internationally agreed means of service that is responsibly calculated to give notice, such as those authorized by the Hague Convention on Service Abroad of Judicial and Extrajudicial Documents. That's the Hague Convention. Second, if there is no internationally agreed means, or if an international agreement allows but does not specify other means, by a method that is reasonably calculated to give notice. I think they could probably fall under that one. We'll see where they go with this. Or third, by other means not prohibited by international agreement as the court orders. All right, so 2 and 3 would be the plaintiff's wiggle room. Let's see how they're going to factor this in and what the court's going to use to allow this. Here's some more law. District courts are given discretion to determine when the particularities and necessities of a given case require alternative service of process under Rule 4F. And then here's some jurisprudence. Rio versus Rio. A party does not need to attempt to serve process under Rule 4F1 and 2 before requesting to serve under Rule 4F3. It stands independently. Okay, and here is a quote site. Or parenthetical, service of process under Rule 4F3 is merely one means among several which enables service of process on an international defendant. All right, so we're going over the rules for international service. Let's continue on. A court may order service under Rule 4F3 so long as the service, 1, comports with constitutional notions of due process, and 2, is not prohibited by international agreements. And then here's some more law. Trial courts have authorized a wide variety of alternative methods of service, including publication, ordinary mail, mail to the defendant's last known address, delivery to the defendant's attorney, telex, and most recently, email. Okay, so now let's apply the precedents in the law that we have to these defendants. All right, here's subsection 1. Defendants Zhao, Lin, and He. Plaintiff argues that the court should allow it to serve defendants Zhao, Lin, and He via Twitter pursuant to Rule 4F3. The court previously denied plaintiff's attempt to serve via social media. Okay, well, that's our background. However, in light of the fact that plaintiff's continued efforts to locate defendants Zhao, Lin, and He, describes them as international ghosts, have failed, despite diligent efforts, the court will now grant plaintiff's request to serve the 3 defendants via Twitter. As plaintiff points out, the Hague Convention does not apply where, as here, quote, the address of the person to be served with the documents is not known. So that's their safe harbor. That's their hook. The reason that the court gave previously to not allowing the plaintiff to serve Defendant Zhao via Twitter was based on the Hague Convention, and then the plaintiff came back with updated law, and then corrected the court and said, hey, you can actually let us serve because the Hague Convention doesn't apply where the address of the person to be served with the document is not known. Okay, and then so this is the body of law that we took it from. Convention on Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters. Further, other courts have authorized service by social media to international defendants. Okay, and then here's the jurisprudence on that. Who's Here, Inc. versus Oren. In this case, authorized service on an individual in Turkey by email and through Facebook and LinkedIn. And then FTC versus PC Care. And this case authorized service on individuals in India by email and through Facebook. In this other case, St. Francis Assisi versus Kuwait Finance House, and this authorized service via Twitter to an individual in Kuwait, noting that Kuwait was not a signatory to the Hague Convention. So, I mean, the court has a precedent with which to do this. They can serve these individuals that are foreign-based citizens, even though the country that they reside in or that they're citizens of are not parties to the Hague Convention. Okay, let's continue on. The court finds that, under the circumstances, service via Twitter is the best method available to give notice to the defendants of the pendency of this action. Accordingly, the court will authorize service by tweeting a copy of the summons and a link to the complaint to the verified Twitter accounts of defendants Zhao, Lin, and He, personal to Rule 4F3. Okay. Now, before I go on, I just want to say this before I forget. Once these guys, or these defendants rather, Zhao, Lin, and He, are roped into this lawsuit, they have to defend it. All right? They have to defend themselves, because the plaintiff, if they don't file an answer to the complaint, if they don't go through motion practice, if they don't defend themselves every step of the way of this and push back, the defendant, he'll get default judgments. All right? Or not, the plaintiff will get default judgments against the defendant. And that's pretty much like a default win. If you go and you file a lawsuit against someone and you serve them and it's effectuated and the court recognizes that you properly served them and that defendant does not answer that lawsuit, you can go in and file a default judgment, get it confirmed, and you win. You get whatever the judge awards you, right? You'll win. All right, default, by default. So, CZ, Lin, and He, my prediction is that now that it got real, I mean, let's be honest, CZ probably knew about this, right? I mean, it was tweeted at him. This made somewhat decent news throughout the circuits and the rags and social media. More likely than not, I know the guy's a billionaire. He probably knew, or this was on his radar, right? Now, I foresee that he's going to send his war dogs, his attorneys, into court to actually push back and fight against this lawsuit. I mean, he should have done that all along, but he was taking the approach like, oh, maybe if I ignore this long enough and duck it, I can actually get away with it and they'll dismiss it for lack of jurisdiction. And I can, continue on being an international ghost. But it's really interesting that the court finally came to a change of heart amidst everything that's happening right now with the whole Ukraine-Russia thing, the China-Taiwan thing, all of the U.S. sanctions. It's interesting, the timing of this, now that the court has changed their tune, and, all eyes are on crypto and people trying to avoid sanctions with crypto and all that FUD. It's just really interesting, the timing of all of this. But let's continue on. We're almost done. All right, part number 2, Defendant Coley. This is the nomad. All right, plaintiff also requests to serve Defendant Coley by serving her counsel or by publication. Plaintiff has undertaken extensive efforts to locate Defendant Coley but has been unsuccessful. The court notes that serving Defendant Coley via publication is not the best method to give her notice of the pendency of this action because, as plaintiff notes, her whereabouts are a mystery. So exactly, where would you publish, notice? How would she get notice of that? Do we have a Twitter? Let's find out what's going to happen. Thus, the court will consider other alternate means of service. Okay, fair enough. Plaintiff requests authority to serve Defendant Coley's counsel. Courts analyze the communications between a defendant and defendant's counsel in deciding whether, as a method of alternative service, a defendant's counsel may accept process that he would otherwise be unauthorized to accept. So here's the precedent, the jurisprudence from a case, BMO Harris Bank versus Gunthmiller, that set forth the precedent that, hey, if we're going to allow a plaintiff to serve a defendant through their attorney, then we have to look at the court has to look at the communications between the defendant and the defendant's attorney and use that as a means to decide whether or not the court will permit the plaintiff to serve defendant in that alternative means through the defendant's attorney. Okay, so continuing on. Indeed, courts may authorize service on a defendant's counsel where the circumstances show that defendant was likely in communication with his or her counsel regarding the suit. Okay, so here's another bar that we got set, and this is taken from Rio Properties. And they said in that case, it authorized service on a defendant's lawyer, but noting the attorney had been specifically consulted by the defendant regarding the lawsuit. So pretty much they're setting out the law, the precedent, that if a defendant has been talking to their attorney, and even more so if they've been talking about the lawsuit, the court's going to let the plaintiff serve that defendant via alternative means. So let's continue. All right, and then here's another one where they authorize service on a domestic defendant where the defendant had notice of the suit through the attorney. All right. And then another one, FMAC loans and receivables versus DAGRA, where the court authorized service on a defendant's attorney under Rule 4F3 because his many motions evidence that defendant had some form of notice of the action. So we pretty much get what the standard is here. All right, so let's continue on. Here, we're going to apply the law to the facts. Here, service through Defendant Coley's counsel is appropriate. Awesome. They're gonna, awesome. Yeah. Nice. Plaintiff's extensive attempts to locate and serve Defendant Coley have been unfruitful. Even her own mother described her as a nomad. Oh my God, this is great. Before I continue on, before I forget, this woman, Coley, tried to avoid duck service. We've been over this. And then sent her attorney in to file for a dismissal for lack of jurisdiction due to not being served. And then once the court knew, it's like, okay, hey, we have your attorney here. We're not going to let you have the case dismissed because you weren't served. But because we know you have your attorney here, clearly you've got to be at least somewhat aware. So we're just going to let the plaintiff serve him, the attorney. Beautiful. Beautiful. I love it. Let's continue on. Defendant Coley clearly has notice of the suit as evidenced by her motion to dismiss. Just what I was talking about. Defendant clearly has a notice of the suit as evidenced by her motion to dismiss for lack of service and by her counsel's subsequent appearance at oral argument. Under the circumstances, the court finds that serving her counsel is the best method to apprise her of the pendency of this action. Service on Defendant Coley's counsel is appropriate under Rule 4F3. If she is an international defendant, see DAGRA, and this is referencing back to one of those earlier cases that was cited, but cannot also be authorized if she is a domestic defendant. Citation. Accordingly, the court will authorize alternate service on Defendant Coley by emailing a copy of the summons and the complaint to her counsel of record in this case. The court will also require service by mailing a copy of the summons and complaint to her mother's address in North Carolina and the second home in North Carolina by first class mail. All right, here's the Conclusion. Accordingly, it is ordered, here's the order, granting the plaintiff's second motion for extension of time for service and alternative service as outlined above. All right, so this was the title of the plaintiff's motion, second motion for extension of time for service and for alternative service. It is further ordered that extending the time to serve defendants Zhao, Lin, and Hay and Coley be extended by 60 days, dated this first day of March 2022. And that's it. Beautiful. I love to see common sense justice like this, where a court is going to refuse to let defendants that would otherwise try to operate as international ghosts and rely on, these laws that are down in the weeds and loopholes, like, exceptions and parts of this Hague Convention to try to circumvent actually coming and answering for their acts, right? And having a day in court. And so, this is great. At first, when the court first denied the plaintiff the ability to serve the defendants via alternative means through service and cited the Hague Convention, it appeared to me that that order, the original order denying the alternative service, was due in large part to not wanting to rock the boat in terms of, international jurisdiction and trying to overexert the United States' jurisdiction over international defendants. But here, I guess, there was some good law that the plaintiff cited, and I guess, like I said earlier, it's this whole time frame is very, not suspect, but very, I guess suspect is fine. But yeah, all in all, interesting development. It's good to see now this case is going to go forward. All of these major defendants have been wrapped in. Another point of note, I wonder if Brian Brooks, he works for, I forgot the name of it's this company, Block Fury. I think it might be Block Fury. Anyway, he was the president of Binance US for like a brief minute and then abruptly left. I'm assuming because he didn't like what he saw there. And it's going to be interesting if the plaintiff is going to attempt to bring Brian Brooks in, because he testified at those congressional hearings before the House Committee on Finance, I believe it was, alongside Sam Bankman-Fried, the CEO of FTX, and some representatives from Coinbase or whatnot. So it'll be interesting to see if they wrap in Brian Brooks, because the plaintiff in his original complaint noted Brooks and said that we might want to rope him in later if discovery reveals that he played a part in this lawsuit. So all in all, really good stuff. I really enjoyed doing this analysis for you guys. Please let me know what you think down in the comments. If you like this, please hit that like button and subscribe to our channel. That would really help us out getting the word out going forward, and kind of spreading more knowledge and wisdom regarding blockchain law, policy, and regulation. So all in all, thanks again for watching, you all. Really love doing this content for you, and we will see you all in the next video. Oh, and before I go, just a small correction. Brian Brooks, he's the CEO of BitFury, not BlockFury. It's called BitFury, and they're a company that focuses on mining equipment and on-chain analysis software. So that's that for the record. But thanks again for watching, and we'll see you all in the next video.